Thank you. Thank you. Let me start with just getting this thing actually pulled up here. Okay. All right. Oh, there. Start here. The first page. So to set the expectation, what we're going to go through today is not going to be like line by line of all 10 pages of this thing. I'm going to highlight all of the things that are either specifically interesting to me or specifically different from what we're used to, just to make sure that they're the things that you're looking out for. I created these notes in this presentation on the basis of thinking about us receiving this contract as listing agents and just understanding what we're dealing with and making sure we're clear on where there are differences. To be clear, I don't have any intention of this being the contract that we use as a company in the near future or anything like that. But we are going to run across it at some point here if you haven't already. So I do want to make sure that we're as familiar with it as we can be so that we don't make any grave mistakes, just assuming that it's similar to our current contracts that we're used to, and then have a seller sign it and then find out that it actually isn't the same. And honestly, I would say this contract is much more beneficial to a seller than it is a buyer versus our current contracts that we see both from inside of our company as well as the one most companies are using. So I will say I think this is positive for sellers. So if you're receiving this as a listing agent, there are some things in here that are helpful. So we will jump right in. So right at the very beginning, there's a list of definitions. This is every definition on there, I do believe. And the only reason I wanted to point this out is I think there's a couple on here that are really just good things to know, and they are standard practice even when they're not listed as definitions with specific statements next to them. But a lot of it, I've had a lot of battles about how we're counting days and what does acceptance mean and that sort of thing. So there's some clear definitions here. The three I wanted to point out are towards the bottom there, where you see specifically days, meaning calendar days. I've had people who I think at times they make a mistake and they realize they miscounted, and then they start saying, well, I didn't think Sundays counted, or the one day was Thanksgiving, so I didn't think that counted. That's never true. Days is always the actual amount of days that have passed. Date of acceptance is another one on there that I think is interesting. That's the date the final offer was actually communicated as accepted to all parties. So if an offer was signed at 10 p.m. and at 9 a.m. the next day is when the agent who had to get the last signatures communicated that to the other agent or emailed the actual contract, that means at 10 a.m. is the date of acceptance of that day, not the day that the signature is timestamped if it's an electronic signature. That's another one there's been a lot of fighting about, that people complaining that the timestamp is the thing that dictates, but when you've got clear evidence that the timestamp and the date of communication of acceptance are different, the date of communication is the thing that matters. And then lastly, the days after acceptance. Again, if really what it boils down to is you have to remember there is a day zero. So the day you receive acceptance on something isn't the first day of the 7 days you have to do an inspection or the 5 days you have to fill out a loan application. It's day zero. And that's always been the case. But again, there've been battles about this. So I think it's pretty helpful that these are right here at the top of the first page. So all parties are operating on the same playing field about what to expect and how many days really have passed or not passed. The other stuff on here is all really self-explanatory. You see things like who a buyer is, who a seller is, what a contract is. I don't think any of those are all that necessary or helpful, but they're on there. Now, just below that, as you see these are the actual, these are pulled out of the contract, so you can see the line numbers to the side there. You'll see in a lot of places where you have to fill in an amount of days. You see right there on line 23, blank days, and then it says 3 days if left blank. All throughout this contract, anytime you have to put in an amount of days, if nothing gets put in there, there is a kind of like a diverted standard that, okay, this is what it's going to be if you didn't fill anything in. The thing I wanted to point out about this specific language here is that you'll know our contracts and pretty much every contract I've seen in the last 5 years, unless an agent added language about needing a proof of funds or a pre-approval by a certain date or within so many days of acceptance, there is no language about that. The assumption always has been that that stuff is not a part of the agreement in any way. It's just the thing that causes your seller to take them seriously. Here it is actually in the contract. And if a buyer doesn't do what they're supposed to do and provide what they've been asked to provide, the seller does have recourse. That's another thing about this contract throughout is anytime there's something that a party is supposed to do, if they don't do it, the other party has recourse that's named specifically right in the contract. So you'll see here, basically, if it's not provided within the amount of days, that the seller has the right to cancel the agreement for a certain amount of time. Because that's the other important thing here. It says they've got 3 days from not receiving it. And then they've got a 10-day period where they can cancel the contract. Also in here, you'll see the word waiver a lot. I'm going to continuously say that as we move through here. But when people don't do something that they had the right to do, that means that they specifically waived their right to do that. So what that means is if 2 weeks in, the seller's unhappy with the financing process, and now they're like, well, they never gave us a pre-approval letter, so we can kill a deal. This clearly states that the sellers waived their rights to kill the deal. They had a time period to do that, and that time period has passed. So they've waived those rights. The financing contingency language, totally different than what we're used to, I would say. For the most part, the financing contingency language in most contracts that we see now has a sentence or two that's pretty plain that just says, if a buyer makes a good faith effort to get a mortgage and they get denied, that everybody signs a release. And that's all it says. So then the fighting that goes on around that is, well, I don't think they made a good faith effort, so I want the earnest money. Well, who decides what a good faith effort is? A judge. So here you'll see at the top, similar stuff to what we'd always see: an amount of time to fill out an application, a type of loan. And then when you get down in there, there's 2 bullet points that, even though there's only 2, I think they cover quite a bit that would be kind of in that, like, did they make a good faith effort or not, or a best effort or not? So you see it specifically talks about providing all the necessary information that's required of the lender to get a mortgage. That's definitely been one that's been questioned, that I've been a part of those battles. And then secondly, a buyer maintaining credit and funds to close. Those would be the 2, I think, when you saw a buyer lean on that financing contingency, thinking like, well, I don't really want the house anymore, so I can just like figure out a way to kill my deal, and it won't look like I really killed it. It'll look like I just got denied. So that covers quite a bit. Now you'll see at the bottom there, that blank line number 40. This kind of takes the place of the stuff that's normally on our first page, where you'd lay out the purchase price and then the earnest money and then the down payment and then the loan amount. And I've told people constantly when asked that it's really important to fill that out, because that kind of cements what your financing contingency terms are. If you don't put any down payment in there, you may not end up being qualified for the 20% down you plan to put down, but you could put 15% down. And if it's not in there, you're kind of stuck. Here, you can fill stuff like that out and make those terms of the financing contingency. And that could go as far as, you could put an interest rate on there. And then if the buyer can't get that interest rate, they don't have to buy. So understand that if you're receiving this as a listing agent, if you see things like an interest rate on there or a term of a loan that doesn't seem realistic, accepting that offer kind of sets your seller up for failure, because the buyer has a way out if they don't like the deal. And I'm sure a bunch of us on this call have had buyers try to back out because they didn't do enough research up front on what their financing was going to look like. And then once they found out, they decided they didn't want to move forward anymore. So this is a place where an agent can do that now, where we have not had that option previously. Appraisal contingency is specifically separate from the financing contingency for a couple of reasons. One, you can have a cash sale where there's an appraisal contingency. The thing I would say about this is, because it's specifically in here, I'm not sure that there's nearly as much protection for a buyer who is getting financing and has a low appraisal as being covered by the financing contingency if they check no to this. So again, if you're looking at this as a listing agent, I think that if it's a finance deal, you're going to see that as checked yes. And if it's not, I would have a conversation with the other agent and make sure that they understand, because I think we're going to encounter agents using this purchase agreement that don't understand it. So as a listing agent, we may need to help them understand it some at times, or at least make sure we're all on the same page. Because again, if we're not on the same page and something goes wrong, everybody ends up upset. So you want to make sure this is getting filled out correctly, I suppose. And this has a home sale contingency language built right into the contract. So that's what you see here. Obviously, we're used to seeing that on a separate addendum usually, or just in like additional terms or something. Here, there's actually a spot where you're checking whether it is or it isn't. If nothing gets checked here, then it's not contingent on any kind of a sale. There are separate addendums that the state has created. One of them is a home sale contingency document, so that would most likely be attached as well. But just know that language is right embedded in the contract permanently here. Okay, earnest money. The thing that's different about this than what we're used to seeing is this again gives a seller a very plain remedy to cancel the contract if the earnest money is not deposited. So you'll see in there now, these days could potentially change at times depending on what people filled out, but each action sets off another set of days, and then the seller has an amount of days if they don't receive the action required, which is proof the earnest money was deposited. Which again, I think is helpful. We've definitely had sales where we're the listing agent and the buyer just disappears 5 days into the deal and earnest money hasn't been deposited. We're not exactly in a situation where we can just deem that deal to be dead. We're busy trying to hunt down the earnest money and hunt down a release. Where here, it basically kills the deal for the seller if that's what they wish. All right. This is the same language, but you see it in here. In our contract, it's kind of buried in the financing contingency section, which is weird, but that's where it is. Here, there's a specific section that just names what happens with the earnest money. It's no different than our current policy or anybody's current policy for that matter. It says clearly that a release has to be signed in order for earnest money to get dispersed, or the court's going to decide. And if nothing happens, that the earnest money will go back to the buyer after 2 years. So no different than what we're used to, but it is very specifically spelled out in a paragraph only regarding earnest money. So a little easier to find, I suppose. I think this is fantastic, truthfully. This is the list of fixtures. These are not the ones you check off though. So the contract has this massive list of fixtures that they're just basically saying, if any of these things exist, they're fixtures, and we all agree to that. So I will say, as a listing agent, it's really important that if there's something in this list that your seller didn't think was a fixture, that you figure that out right then with them. And there's nothing wrong with putting a line through one of these and calling it not a fixture. That's fine, but it's really important that you have that conversation up front. And I think it's nice that this is in here because it will force that conversation to happen, as opposed to, I know I've had it numerous times, I'm guessing other people on this call have as well, where it gets down to closing and the buyer thought something was a fixture that the seller thought was personal property. Now, the list is endless. There's always going to be something that's not on the list eventually, but this is a way more exhaustive list than anything we've ever had before. So I think this is a pretty positive thing. And then into the inspection section, the one thing that's not in this presentation, just below those fixtures, is the standard stuff that we check boxes for, things like appliances and window treatments, that sort of thing. Now, in the inspection section, one thing you'll see here that's interesting is you'll see there's part 1 and part 2. There are plenty of places in Ohio that just have like a due diligence period, as opposed to specific inspections that you have contingencies for. So we may start seeing some of that where agents just check that first one and then the buyer has 10 days to do whatever inspections they want, as opposed to just general, radon, and pest, or something like that. But then there is the second choice you see below, which is what we're more accustomed to. I don't think one's better than the other, but it would be important that you can distinguish for your seller what the difference is. If you see that top one checked, that they understand that means that there are no limits to what the buyer can do in the way of inspections. And likewise, that the one down below is beneficial for a seller in the sense that it's totally limited, and you know exactly what you can or can't go back and renegotiate over. All right. The inspection period section, no, it's no different than before, but it is it's separate from the list of inspections. So it's literally right below it is where you'll see in that top, it says 10 days if left blank, but that's the place where, so you wouldn't name different periods for different inspections. You just would have a whole period to get whatever inspections you checked off if you itemized which inspections you were doing. And I will say down below, you'll see on line 216, that other blank. In most contracts I've seen, and definitely in ours, the timeline of communication after inspection is clearly defined and is standard. Here, you have the ability to manipulate it. So it does say that a buyer is submitting their contingency removal or waiving their right to renegotiate or back out after the last day. So if you've got 10 days to do inspections, if you did the inspection on the 10th day, you don't have 3 days from the 10th day. You got to submit that ROC on the 10th day, or else you've waived any contingency rights you have around the home inspection, or whatever inspection for that matter you're doing. So that is one important difference to distinguish, is there's not inspection time, response time, and then seller response time. There's just inspection period, seller response time. Because down below there on 216, what that's saying is the amount of time the parties have to come to a final agreement. Basically, that's what they were referring to that as a remedy period, as opposed to like seller response time. So in essence, it's not seller response time, it's everybody's time. So make sure that you're paying attention to that as a listing agent. And that's another one where I would say if a buyer's agent writes 3 days in there, you may want to ask them about that, because they may think all that is seller response time, but it's really not. It's total remedy time. All right, point of sale inspections. If you were in the meeting on Tuesday, I talked briefly about this. Here you see it says very clearly that the seller is going to deliver the property violation free. There are definitely brokers contracts out there in our world on the east side, where all the point of sale inspections are for the most part, that have this language currently. And there's been times where we've been the listing agent and we've missed that, and we've assumed that if the point of sale is not specifically negotiated, that means it will be negotiated once it's completed. And this contract makes it very clear that if you don't manipulate that language, and if you accept an offer with a pending point of sale inspection, the seller is saying that they'll fix all the violations and make it point of sale compliant. This, we have that Megan's Law paragraph. Almost every broker currently has a Megan's Law paragraph. The one thing I've always found interesting about that paragraph is it sort of says it's the seller's responsibility to disclose any sex offenders they're aware of, but then a sentence or two down, it also says it's the buyer's responsibility to do their own research. So it's kind of contradictory. This one, in regards to the Megan's Law stuff, it's very clear that it is completely the buyer's responsibility to do whatever research they want to do, and that it's not the seller's responsibility to provide the buyer with any information about it, which I think is beneficial. I think our current contract creates a little bit of a gray area around that. Now, they've incorporated other things with the Megan's Law in here. So you'll see it's also offsite conditions and property use. So those things are designed specifically really to protect us. There's been many lawsuits, luckily, that we haven't been a part of, where people have gone back and sued agents for offsite condition stuff, like a year after closing, the airport expands, and now the airport is only 300 yards from their house instead of 1,000 yards. And it turns out that there was information out there that was publicly available that said that this was going to happen. And the agent wasn't aware of it, didn't tell their client. And now they're going back and suing the agent and broker saying, like, you were aware of this, you were supposed to be representing me and you didn't tell me. This puts all of that stuff on the buyer to make sure that the property is able to be used the way they want to use it, and that they've done the research they need to do about any offsite conditions that would affect the property in a way that they don't like. So that, again, only to protect agents and brokers pretty much, but also to kind of put people on notice, like, hey, make sure you've thought about this. All right, tax prorations. Understood there's two choices in here of how to do tax prorations. We use what's referred to here as the long method, which is the 365 days. You know, when we have a closing happen, a seller credits a buyer 6 months plus however many days have passed in the current 6-month half tax cycle, right? There are places in Ohio that don't do it that way, I guess. I truthfully don't fully understand how the places that do the short method even do it, but I would say it's important that you note that if you got an offer where the short method is checked for some reason, that you talk to the other agent about that, because the short method wouldn't apply here at all, ever. So just know the long method's the one we use, and that's the one that should always be referenced when you're in this section. The homeowners association list, I find this interesting and helpful. This kind of says that the seller would provide any of these things if they're available. I think for any of you that sell a decent amount of condos, there's always a lot of difficulty getting certain pieces of information, especially if you have a buyer who has maybe owned a condo in the past and it didn't go real well because of the HOA. They start digging and they want more than just, you know, bylaws and rules and regs. This kind of says, like, here's all the things that a buyer could reasonably ask for. And that's a heck of a lot longer list than the things we normally get. So again, if you're a listing agent listing a condo and you get this contract, it's important you go through this list of things with your seller and confirm which of these things you could actually get, because accepting the offer kind of makes, you're making the statement that, like, you'd be able to get these things. And if there are things that you can't get and you kind of agreed to be able to get them, it just kind of turns into a mess, I think. So just know that that's on there and make sure your seller's aware of it. All right. So title insurance and title search. So all of the closing costs are not as flexible as I think people thought they were in this contract. But, you know, in our contracts, it just says who pays for what. But because it's done differently all over Ohio, I mean, there are things as strange as, I believe in Cincinnati, I discovered that the seller just always credits $300 towards a title insurance policy. Doesn't matter how much the policy is. It could be a $500 policy or a $3,000 policy. It doesn't matter. The standard there is $300 bucks. Our standard obviously is a split at 50-50. And the seller pays for the title search is what's normal here. So there's not really a great way to even reflect that. What I would say is just be aware of this, that things could be being split a different way than we're used to, because this contract gives the buyer the option of how they want to see them split. So just know that that's in here. And if you're busy telling your seller, like, oh yeah, this is how we split fees here, it's, you know, you each pay half the escrow fee, you pay half the title insurance, you pay for the exam, they pay for the financing charges, blah, blah, blah. Just know that's not necessarily going to be the case here, and just be aware of it and make sure you point it out to your clients. Property survey. One thing I think is interesting here is a lender is always going to require a location survey, I believe. I don't know that there's a deal that a lender does where they don't require a survey. So if it's a finance transaction and they said it's not contingent on the property survey, again, like, ask a question of the other agent to say, like, are we sure we can even do this? Do you talk to the lender about it? Obviously with cash sales, things like title insurance and surveys are two things that the title company just asks the buyer if they want. I think our answer to our clients should always be, yes, you should get a survey, and yes, you should get title insurance, just because that's the safe answer. But here, obviously, you've got right in the contract the ability to do it or not do it, which our contracts don't allow for. On a cash sale, there's no place where the client gets to pick whether they want it or don't want it. Obviously, a buyer is always paying for the survey, so there's no language in here about who's paying for it. That's always on the buyer side. Closing. There's two choices for what closing is. Obviously, you put the date on line 339, so it's buried very deep in the contract, as opposed to being right up front. But note that there's two choices there, and I think if you read them, you almost think to yourself like, oh, those sound like they're pretty much the same choice. There's one distinguishable difference between the two. One is, so that the top one is saying when the buyer signs everything and the seller signs everything and the buyer's funds are all at the title company, that's the moment of closing. And then the bottom one is once everybody's signed everything and all the funds have been dispersed by the title company. So the one that we have been doing since 2021 is the bottom one on line 383. Neither one of these are right or wrong. I'm happy with both of them, and you could pick whichever one you want, but just know, as far as your seller's concerned, if you receive one of these, that you're clear on what closing is, because there could definitely be times where the transaction's funded and doesn't disperse till the next day. And in that scenario, you'll have a seller who's saying like, well, I haven't gotten my money yet, I'm not giving keys over. That's not what closing is if you pick that first one. So just know that. Like I said, there's not a right or wrong here. I think as long as your seller's on the right page with what's true, either one of those is fine. And either one of them is clearly acceptable, because depending on where you are in the state, one of these two has been the standard for the last 2 years. All right, compliance with dates. This paragraph doesn't look all that sexy or exciting. But there's a reality here that I think is important that everybody's clear on. Even though our current contract has dates for everything, there's no language that says very specifically that those dates matter, which I know seems redundant and dumb. There ought to be able to be, if there's a date in the contract, that date matters. But unfortunately, without this times of the essence language, those dates only sort of matter. They're a lot fuzzier in our contracts. But just by putting this, I don't know, what do you think that is, 25 or 30 words maybe in there, it holds everybody specifically accountable to specific dates, as opposed to kind of blurry timeframes. So just know that those three lines are very, very important in this contract, even though they don't appear as though they might be. And so lastly on here is dispute resolution comes in at the end. The one thing that's advantageous here is everybody agrees to go to mediation over a contract dispute before anybody can file a lawsuit. It clearly says in there that if you can't mediate, that the next step is you can, file legal action. But I do think that forcing people to do some mediation at least forces people to have a rational conversation about what they're upset about, as opposed to just like have an attorney fan the flames of the fire and start driving everybody wild. And this one, I was in Columbus when this got rolled out, and John Deegan, who's one of the two attorneys that wrote a decent amount of this, his points about this were really good. I mean, for those of you who don't know who John Deegan is, he's the head of legal counsel for all of Howard Hanna. And the point he made about this I thought was great, was that if only he had an opportunity to mediate problems with people who had a problem with their agent or with the brokerage as a whole, he felt like he could resolve them and make them happier than having won a lawsuit, because the lawsuit takes forever and it costs a bunch of money. And in the end, a lot of times these disputes are about money. And if it costs you a bunch of money to actually handle the dispute, you're really not that far ahead. But it's important that your clients know that this language is in here, just so that they understand that they're agreeing to be forced to try and mediate a problem or disagreement contractually before being able to just like jump the gun to a lawsuit. I would say, especially if your client's an attorney, make sure that understand this, because I feel like attorneys are happy to just start filing things because it doesn't cost them anything sometimes. But so those are my big highlights. I haven't even seen the chat. Let me escape out of here, and I'm certainly happy to answer any questions. Does anybody have any notes about sections that they've got questions about or want to discuss further? What do we have in the chat?
I had a quick question, Andrew.
Go ahead.
In that long list of fixtures that you showed, could you clarify? I think there needs to be clarification. The one said grill, cooking units, exterior, and like a grill to me is like something that's very movable unless it's planted in the ground with a gas line.
I think that you're right on that. That was one that I looked at and thought that seems weird, but without it being very clear, I think it's fair to say that what they're talking about is like a hard piped grill that is fixed, to either like an outdoor kitchen or just, a pipe coming out of the ground with a grill on it.
Okay.
But yeah, I think you're right. I think like even if the clarification was as simple as hard piped gas grill, or some language that made it clear that it was like not a propane grill,
right,
or a charcoal grill for that matter, I guess.
Right.
Yeah.
That seemed that it was too vague in the explanation. It should have actually had something in it.
I would say that would be one though where you would just, if you had a seller that just had a propane grill on the patio, you just put a line through that one.
Okay.
And I don't think that would ruffle any feathers. I mean, I don't think the average buyer would assume that a propane grill was a fixture to a house.
Exactly, but I just felt like if they're being they put all those things down there, they could have been a little bit more explicit in that one line.
Well, that's why I said that list is way more exhaustive and way better than what we currently have, which is just an implied understanding of what a fixture is.
Right.
So
you're
that
saying
list is better, but yeah, I mean, there's, you could make the list 3 pages long, and then there'd be one that needs to be on the 4th page. So it kind of wouldn't matter how exhaustive you made it, I think.
So this would be when you're representing the sellers. Mm-hmm. And if something's on that list, they then would have to change the purchase agreement and cross out whatever they don't want.
Yeah, and that's why I point that thing out, because I think, because again, we're looking at this through the lens of being a listing agent receiving it, because we're not using this contract as a broker.
Okay.
So your interaction with it is going to be representing a seller. So that's why it's important to understand that fixture list and make sure your seller understands it. Because they may look at it and say like, oh, well, we weren't planning on leaving that. We didn't consider that a fixture. And that's fine. This contract isn't saying you're forced to agree that all these things are fixtures, but it is saying if you agree to this, these are fixtures. So you just have to put a line through it.
Yeah, I mean, I didn't read through all of them. Obviously, they were on the screen there, but that one pointed out to me. The other one is that comes up sometimes. There's like the mirrors that go with the vanity. Do they stay? Do they not stay?
Yeah, and that one, I don't recall if that one's in there. But the other one that's specifically not in there is outdoor play sets. That's another one that comes up a lot. I mean, I've had 2 enormous battles myself in 15 years over play sets. And children and fathers and mothers crying in the backyard because the play set they thought was staying at the house wasn't there. Right? I mean, it's always ugly when people have the wrong expectation. But yeah, and that's why I think the longer that list is, the less opportunity there is for somebody to have the wrong expectation. But it doesn't mean it still couldn't happen.
Yeah. Thanks.
Anybody else? One thing, has anybody seen this document as a listing agent? Okay. Yeah, I'm not aware of any brokerages who have fully rolled it out yet, but I think in the next few months, you will see it, depending on where, especially like where you do business. I mean, I think there's a pretty good chance that Keller Williams, Northeast and Menor will start to use it. I've been told that Howard Hanna is going to use it, but nobody is yet. So obviously, if Howard Hanna uses it, you're gonna see it. Trying to scroll down. Okay, I see there's a question in the chat. If representing a buyer and the listing seller requests that we submit using this contract, do we comply with them? Okay, yeah. So it's an interesting question. This has been a question for a while because of the recent move, more so on the east side than the west side, but even some on the west side, of agents from like Warren and Youngstown wanting people to use the Youngstown Board of Realtors approved contract on their listings. You don't have to comply. I mean, the contract that gets used is certainly going to be, it can be a negotiation. If you want to use this as with a buyer because the seller is, sort of demanding it, my answer would be that you can. And then my second piece of that answer would be, you need to make sure you understand it before you use it. So if you find yourself in that situation, go over it. Call me if you want to call me. We can talk it over too, but do not just use it because you're forced to and have it be the first time you've actually sat down and looked at it and understood it. But no, there wouldn't be anything wrong with using it in a situation where you feel like that's to the benefit of your buyer. Will the new form be a standard for the whole state? No. Every broker gets to pick what contract they use. The state does not dictate what documents we use or don't use. So that's decided at the brokerage level. This document is, what's the right word? Endorsed by Ohio Realtors, meaning like the Ohio Association of Realtors. So it's a form that's available. It's out there. It's endorsed by our trade organization, but it's something that's decided at the broker level. How many pages is the note? I believe it's 10, if I remember right. I know the first one I got was 16, but it was, I think it was like 12-point font. So then they made it smaller font and it went down to, I think, 10 pages. Well, Jade says 9. So maybe I'm wrong. Maybe it's 9. Anything else? Anything else anybody wants to discuss? The questions you saw in there, or just more explanation of things that I brought up that you didn't quite hit home? No? Okay. Well, I think we're all set then. I'm happy to have done this in under an hour. My goal was to do it in about 40 minutes to an hour. So thank you guys all for being here. And as always, I end every time I'm giving a presentation like this with, if you have any questions or you run into any problems regarding this or anything else, please call me. I'd rather talk to you about your questions than talk to you about your mistakes. So don't hesitate. If you get one of these tomorrow on a listing and you're not quite sure of something we talked about, or you've got more questions, let's talk about it before you go to your sellers with it. To make sure that you're doing the best you can for them and that you're clear on what it is you're presenting. So, all right, excellent. Well, do we have any more? I keep getting things that say new messages. Oh, they all just say thank you. Perfect. All right. Well, thank you guys. Thank you all for being here. I appreciate it.